Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guests include Amy Schmitz. She's the John Deaver Drinko Baker and Hostetler Chair in Law and Director of Justice Tech for Moritz College of Law at The Ohio State University, and Janet Martinez, who is a Senior Lecturer in Law Emerita from Stanford Law School. Welcome to you both.
Thank you.
Thank you. Looking forward to this.
Well, I am really excited to have you both on the podcast because you are experts in dispute resolution. It's something that is near and dear to my heart because I, at one point a long, long time ago, taught negotiation. And of course, this is such a hot topic for all attorneys. There's so much alternative dispute resolution in the practice of law. But you all have just authored a book, a first edition book called Digital Dispute System Design Using Technology in Preventing and Resolving Conflicts. And that is a much more evolved topic related to dispute resolution. And I'm really excited to hear about this book. So this first edition should be out in a few weeks from Aspen Publishing. And so please share a little bit about what prompted you to write this digital dispute system design book.
Yeah. So first of all, just for those that listen to your podcast, we planted the seeds for this, talking with you on this podcast in 2023, really noticing, of course, the rise of AI and other technology tools and digital platforms and really how it's transformed dispute resolution. We no longer simply think about humans, but now we do have to think about technology as playing a role. And it's been just amazing working with Janet Martinez because she really is an expert in system design. So together thinking through, well, wait a minute, how do we be sure that we are using these different technology tools in a way that's intentional, informed, and that really plays an important role in dispute prevention and resolution? And how do we help our students who would like to work in these areas and are excited about these different possibilities for their careers? So we thought, well, we need a book for this to help instructors and teachers who would like to teach in this area.
Well, I have to say, I think you're the first guests that have a book that resulted from a connection on the podcast. So I'm super proud of that. Thank you for sharing that little fact. And certainly lots of reasons why this book is necessary. But maybe you can share for our listeners some of the foundational concepts that can be found in the book.
Oh, yeah. So we have a lot of themes that run throughout the book. First of all, is really thinking about technology as the fourth party. So in dispute resolution, we think about the parties, the claimant, the respondent, the plaintiff, the defendant, and then you think about the third party neutral, mediator, arbitrator, judge. But now technology really plays a role as the fourth party, and you have to take that into account, and it really does matter in dispute prevention and resolution. So that's one of the pieces. Next, we talk a lot about sort of the innovation paradox. So technology can both create and resolve conflict. So in some ways, we see a lot of new and more and different disputes because of technology, but also how can we harness this power to help us in resolving disputes? Also, humans in, on, and out of the loop. That's been used elsewhere. We didn't make that up. Love to claim it, but we can't. But you have to think about, well, where is the human in the use of these different technologies? In AI, for example, we are seeing more and more of autonomous AI agents, right, where the human is out of the loop. But in most of the uses, and in the uses in the law in particular, the human needs to be in the loop. In other words, the decision does not come out, it doesn't impact anyone without a human involvement to be sure that it's correct, to provide the correct role, what you need for the particular problem and context and the stakeholders involved. I would also add that really system design and the foundational concepts of system design and dispute system design. And this is where I really have to hand the baton to the expert, which is Janet Martinez, who wrote a really foundational book with her co-authors. So maybe Jan wants to chime in on really system design.
Okay. So system design, really, I had occasion to look at my dissertation from 25 years ago, and that's when I first started thinking about system design. The focus being at two levels: to take a more systemic approach rather than an ad hoc approach. As lawyers, we usually have a client who comes to us with a problem, and we deal with how are we going to solve this particular problem. Broadening the scope is to ask, are there a bunch of cases that are like this, that have the same kind of character or profile? And do we want to come up with a more regularized system for dealing with those particular disputes? And to regularize, I mean, do we want to have one or more processes that we sequence or offers a menu to solve the particular problems at hand? So whether this is medical malpractice, whether this is landlord-tenant, whether this is multi-party environmental disputes, these are categories of disputes that we might want to come up with a systemic way of dealing with it. So by system, we just mean one or more processes sequenced or combined or offered to resolve a given dispute. And then also to expand the time frame for resolving a dispute. Do we want to intervene at the beginning with better data, which AI can and technology can offer? With better data, we may not even have the dispute manifest. Implementation, maybe we have an agreement, but we haven't really sorted out how we're going to implement that agreement. And then we have the more normal enforcement actions that we're used to as lawyers. So I think from a system perspective, thinking about what it might look like, one or more processes, what kinds of disputes are we looking at? So the system design started with that precept, and my particular work was looking at the World Trade Organization, which has a pretty developed system. The other piece of the system design then was to come up with a framework, and that was to really focus on what are the goals? What are we trying to accomplish here? Who are the stakeholders? What is the situation? Is this a crisis like Katrina or a hurricane, for example? Or is this something that is just endemic and less critical? What processes are available for us to use? And do we have a means of really evaluating whether we're effective as a system of processes for dealing with that conflict? The system design idea is really juxtaposed with Amy's work working at technology, and we just sat down together and really enjoyed thinking through how do these pieces all fit together and what can we say that would be useful to students who are entering this evolving world.
It's fascinating putting these two things together, systems design and then this technology use in dispute resolution. But what does it look like when you're in it, right? So when you're using those technologies, when you're playing in the sandbox, if you will, what might I as a professor see in the book that would help me explore this with my students, or what might students learn from these new technologies and how to apply them in a systemic way to dispute resolution?
I can envision the book being used, and it's nice the way Aspen is allowing for bundled with other books. So for example, you're teaching mediation class, but you'd like to include consideration of technology. Then the first chapters of the book, the first 5 chapters in particular, really set these foundational concepts for students, and also include a very robust chapter 3 that really parses out all the different digital tools in the problem-solving toolbox. And I really do think of it that way. If you're a mediator or mediation professor or an arbitration professor or negotiation, you have to be able to think about, well, how are these different tools? How can they be used? How should they be used? Especially in light of the framework Jan was describing. So along with the background, which we'll talk about in a bit, we have 9 chapters that are case studies. Now, somebody might not want to use them all, but they're very hands-on with a lot of exercises. So this book includes a lot of exercises where an instructor can really walk their students through a system design exercise, thinking through, okay, who are the stakeholders? What are the goals? And the fourth party, the technology, what are the pieces? Are we talking about generative AI? Are we talking about legal RAG, retrieval augmented generation? Now we have agentic AI, which we do talk about in the book as well. And then there's, expert systems, rule-based systems that have existed for quite some time, as well as natural language processing, OCR, which has become truly effective, as well as even metaverse and blockchain. So we do have a broad range of technologies that are explained and discussed in the book. So that can be really helpful for an instructor who does want to dive into the technology piece. I would say also, I know I have taught online dispute resolution courses, and what I call dispute resolution in the digital age, as well as my justice tech course. And all of these courses can benefit from a book like this. So there's kind of a wide range of uses depending on what an instructor is looking for. I think we're all seeing how our students are very tech savvy and they're wanting more around the use of technology and responsible use of technology, which is really a big piece of the book as well in ethics.
So we're going to get to ethics in a minute, but I wanted to ask, so you said there are 9 case studies. What might a case study look like? Can you give us an example of one of the case studies in the book? I think that will help our listeners and me kind of visualize what these topics might address.
Yeah, they have a broad range, right? We have everything from metaverse hearings to online dispute resolution and e-commerce, sort of eBay and Amazon. So there's a really broad range of case studies depending on what somebody is interested in. So the way they're structured is they all start with background in terms of the use of this particular tool. It gives you background, for example, with online dispute resolution in e-commerce as one of the case studies. So you get to learn about sort of how it has evolved. We've got Amazon, we've got Facebook Marketplace discussed, as well as eBay, and their online dispute resolution processes that they have in place for a stream, again, as Jan was discussing, of disputes involving these online purchases. And these sorts of online dispute resolution mechanisms have been in place for some time, but they have gone through periods of redesign. So you start with your background, and then there is a deep analysis in every one of the case studies of directly applying the framework. So we go into, okay, who are the stakeholders? Analyzing what the goals are, analyzing the issues that are at play with respect to context and culture. And all 6 pillars are discussed. And then there is an analysis at the end discussing sort of redesign and what ideas for redesign. One thing we're learning with respect to dispute system design and looking at real problems that exist currently is over time you have to redesign, especially with the use of technology and how technology has evolved to kind of change the nature of how those disputes are resolved. Another one of the case studies looks at mass arbitration, which is certainly a new procedure and new process that has crept up, and technology plays a very large role in mass arbitration. So really sort of analyzing that and providing solid way to redesign and think about, well, what should be our concerns? How might we create different rules with provider organizations, for example, to think through how technology should be used in the best manner possible within that context.
So I think building on what Amy commented on, going through the framework elements of the focus at the end, is this an effective and accountable system? And unless you know what your goals were at the beginning and have established metrics for measuring them, it's really hard to know if we're very good or not. So I think that's another part of the analysis and what leads to the redesign. If you have been monitoring all along, you can tell this is where we have some holes, or there's a new technology that really transforms what we can offer.
Now, in all of our AI explorations in the profession and outside, we're all worried about ethics and regulation, right? There's all these hallucinated cases that we're seeing lawyers use in briefs. There's all sorts of warnings that we're giving our students as they engage in this new technology for the profession. What sort of coverage do you have and recommendations do you have in this digital dispute resolution and system design work in ethics and regulation?
Yeah, that's really an important piece to this, and obviously something very important for any of us who teach know how important this is for our students to understand responsible use. So yes, we have 2 chapters that are dedicated. One chapter is dedicated to what we call hard law, meaning legislation, enforceable law. The other is dedicated to soft law, meaning different ethical principles and guidance that have come out from the American Bar Association to other groups that have worked on this. And Jan, I know you've thought a lot about this as well. Maybe you want to chime in on some of the sort of hard and soft law and how that is really a big piece in the book with 2 chapters dedicated.
So an example of hard law is the European Union. They've come up with an act and they have precisely laid out your category 1, 2, or 3. You either either are really offensive and you're harming people, like serving people in the crosswalk, for example, with invasive visual technology. So you're able to track. So is that offensive and is that across the line? Or it can be medium, it's concerning, but there's a cost benefit analysis. And then there are others that are not, don't rise to the highest level of violation. So Europe is ahead, we'll say, not ahead of us. They are in a whole different track than we are in the United States. And so having really precise regulatory structures on what is acceptable technology use and what is not. Colorado, as a state in the US, has followed that lead and is structuring something similar for state law. But all the other states, all 50 of them, have their choices on how they want to regulate. And I think the underlying pinning to keep an eye on is what is the public policy preference that we have here? Is it protecting the population and the taxpayers, or is it encouraging innovation and jobs and creativity in the whole technological field? And how do we balance both the innovative support and the concern for the citizens' well-being? And the United States has just come out with the U.S. AI action plan. The Biden administration was rescinded. They had taken an approach that was going to be more regulatory and structure for citizen benefit. And that was rescinded on the first day of the Trump administration. The Trump administration in July came out with its own action plan. It said, we do not want a lot of red tape and obstructing innovation. And so that's a whole different tone and context in which the regulation will or will not be evolved. So I think that that's an example of the hard law approach. The soft law approach is, you can see, as Amy said, you have providers like the American Bar Association, you have states that come up with their own governance, you have Microsoft that comes up with its own guidelines and rules. So they can be called best practices or guideline or best rules. These are all examples of soft law. We want to be equitable, we want to be ethical, we want to be transparent, we want to be compliant. So these are all under the soft law, but we're trying to operationalize what those means in terms of metric. And so the soft law is harder to manage, and there are many different bodies that are coming up with their guidance and guidelines, and how those are implemented and operationalized will kind of govern the soft law arena.
Well, I imagine all these variations of soft and hard law make it difficult to design a system, right? Because it depends on where you're using it. And if you're using technology, you could be using it with anyone around the world. I know I thought it was fun, Jan, that you said, we're not even like in the same race as Europe. With what they've done, it's a totally different world and framework. But I imagine there's a lot of training to do for our future lawyers in online technology or digital dispute resolution and systems design, because they very likely will be negotiating, mediating, arbitrating with someone across the globe who may be governed by some of these regulations in Europe or other things. So what is the recommendation for students with a book like this and those who look to design systems for how you navigate such wide variations in regulations?
There's different sort of arguments, right? So some can argue, well, you could have a different technology that you use in Europe versus US, for example. But really, a lot of companies, we saw this happen with the GDPR and privacy. The GDPR, as many listeners probably know, it's a privacy law that came out of Europe, but a lot of companies here in the US will work to be compliant with GDPR because they have clients from all over the world. And so similarly, the best practices are to consider the more stringent regulations when you are designing a system so it can be used anywhere and for anyone, especially in a world where lots of transactions happen across border and different people in different places, and especially in dispute resolution and administration of justice. The European AI Act, for example, puts administration of justice in its kind of high risk area where you do need more regulation because you're impacting people's rights. So it's something to really think about. And I know with the book, we discuss this and we actually do some various charts and such where we're really kind of juxtaposing the different ethical principles with the different system design questions and kind of push those questions also through exercises, having students go through ethics exercises where they can discuss this and debate it, right? Because it is a hot debate currently. And even in my own course, Justice Tech, where the students are designing, building, testing technologies to help in areas where people can't afford lawyers, we use the most stringent standards for responsible AI. And that's really important. I believe as a professor, I really think it's important to teach that to students.
I think to Amy's point, the risk and benefit of a particular technology in a particular situation. So I actually see a really opportunity for innovation in lawyering, because if it isn't clear in the regulatory infrastructure, then you need to negotiate terms with your counterparts and the other stakeholders in a given issue. So I think that is going to require a higher level of analysis and inflexibility, which is fun for a lawyer, to try to sort the puzzle. But I see that is really opening the door for even greater legal skills.
So is there any form of digital dispute system design that you think is contrary to the use of these technological tools that are coming out, or any warnings that you have regarding what's available or what you see coming down the pipe?
I mean, certainly there are. One thing, and a lot of this is not in the book itself, but just in terms of research that I know I've looked at over time and thinking through sort of, is the question Jan asked earlier, is this actually helping people or not, this particular technology? Or is it just a rush to get it out the door and to make money? And I do see some fear in that personally, because, a lot of times it's just they're trying to sell. So you can have a software developer that just wants to be first to market, just wants to get something out the door, but they're not being intentional in terms of using system analysis and going through the rigorous analysis and intentional analysis that's necessary in order to actually design a system that will help real people with real problems. So I do think that that can be concerning. I mean, even if I suppose it is discussed, one of the case studies does highlight some concerns with respect to the metaverse, use of metaverse in a hearing in Colombia. And was that just kind of a stunt? Did it really help resolve disputes in any way? And we discuss that in the book and sort of thinking through the stakeholders, the goals, and then is it really helping people when most people cannot afford the various tools that would be needed and the goggles and the whole bit? And is it kind of more of a stunt and not really helping with resolving disputes in a way that is most really in accordance with the law and in an equitable manner? Now, some of the folks who were observers of this thought it was great because it showed innovation and showed they were ahead of the game in terms of using metaverse, but others did note, well, it was clunky, it didn't really work, it was kind of more not really seeing value in it in terms of administration of justice.
I think another angle that has been demonstrated by Amy's class on Justice Tech is the fact that it can't be lawyers alone sorting this out, or computer scientists or engineers. It really is a cross-discipline undertaking. And so as a lawyer, we need to know how to ask the right questions of our computer science designer, because I think, to Amy's point, if they're just keen to get the technology out the door and in use, but they didn't really deeply analyze how that was going to be experienced in the legal context, then I think we're doing a real misservice to our clients. So I think there's a need for lawyers to be conversant and really facilitative in terms of using the technology and understanding how it intertwines with the law.
Well, and I think your book would be really helpful in doing that. But let's talk also about other uses for the book, Digital Dispute System Design, Using Technology and Preventing and Resolving Conflicts. You mentioned that Aspen is unbundling or allowing this to be unbundled or bundled with other books. And you shared some of the courses that this might be useful as an add-on. But what else might a law professor utilize the book for? You've mentioned Justice Tech. Are there standalone courses that faculty could use this for? Let's explore a little bit about that.
Oh, yeah. First of all, as we see the growth of just system design courses, more and more law schools now have a system design course. Well, this book includes the system design analysis and includes very rigorous chapters on those pieces, but it adds in considerations of technology, which I think this is not the future. It's actually now, it's today, it's currently happening. So I think it could be used in a system design course. I also think it could be used very well in an online dispute resolution course. As I said earlier, I've been teaching online dispute resolution courses for a long time at University of Colorado, Missouri here and Pepperdine. So I know a lot of schools do have online dispute resolution courses. So this would be very helpful and would be a perfect book for that, obviously. But I also wonder, I think there's other sort of lawyering in the digital age. There's a lot of sort of new AI in the law courses. I could see it being used in any of those sorts of courses, and it could be used outside of the law school also in terms of public policy courses or even with HR and human resources. So I feel like there's a lot of different uses. Certainly dispute resolution is one of them, but I could see it used in different ways.
Well, that's exciting. It sounds like it has a lot of utility across the curriculum. And as you're talking to those in the academy who might want to utilize the book or explore these topics more, what final advice might you give them or future frameworks might you suggest in looking at these very hot topics and considering how they can prepare the next generation of lawyers in systems design and digital dispute resolution?
Yeah, I mean, one thing, as Jan mentioned earlier, the interdisciplinary collaboration. We're seeing more law schools have these kinds of courses like mine. It involves law students and computer science students working together in teams, and having that kind of interdisciplinary collaboration in your law school education, in your computer science education, really sets you up for success, because it's really important to learn how to work with others, to understand the needs from a very broad perspective, to think through all the different stakeholders that might be involved in a particular process. And unfortunately, in sort of your usual traditional courses in law school, you don't do that. And so I think breaking down those silos and getting students to learn in that way can really set them up for success in the workforce. So that's one thing to consider. I also think it's really important that we think about designing for justice and access to justice, which is another theme in the book, and pulling that together. So another piece of advice is being creative as teachers, as instructors, thinking through how are the different ways that we can really push our students to really think deeply about responsible use of these technologies in a very hands-on way, such as dispute system design or arbitration or mediation or negotiation. Instead of just sort of, one of these courses that's just sort of, here is what AI is. I mean, that's really not very helpful. Students need to be able to think about it in action as used, as applied. So that's another sort of big piece of advice for people who want to get into this. I will also say, when the book comes out, take a look at the teacher's manual. We're providing sample syllabi and different options for how it might be combined with other courses, as well as exercises. And again, I think we all have experienced that students learn by doing, especially now with AI. You can't give a ChatGPT answer to actually doing and applying and hands-on use. And so that's a real focus of this book and courses of these kinds. What do you think, Jan? I know you always have really awesome advice on this.
Well, I think to your point is the exercises will really be illuminative in that by having to look at the goals in a particular context or series of cases, to think about what are the policy goals that we're looking at, because there are usually multiple policy goals that you want, but you can't do it all. There's not enough budget to do everything or not enough time. And so thinking about what are the trade-offs that are being made. Is transparency more important in this context with these kinds of clients, or is confidentiality more important? Is stakeholder involvement more important and agency in making decisions on the outcome? Or is it more important that you have a very precise legal rendering of a particular class and you need to be in a court, like the work that I do in groundwater management? Sometimes you just need to go to court and need a judge, and you need it to be public and really quite transparent. And other times, a more mediative consensual process. So I think that trade-off is something that this gives students a chance to practice with and think through what are the consequences consequences of going either way.
Well, thank you. You've given us a lot to think about, and congratulations again on the first edition of Digital Dispute System Design, using technology in preventing and resolving conflicts, coming out from Aspen early this fall, and hails back to an earlier podcast episode of Aspen Leading Edge. So I'm especially proud. Congratulations. Before we conclude, I wanted to ask each of you what I ask all my guests, and that is, what are your predictions for the future of legal education in the coming decade?
It will become more interesting in ways that we, rather than a standard way of delivering information and practice models, I think that we're going to be pushed by all the AI answers that our students come up with. We're going to be pushed to say, and under what conditions does this hold? And then how do we think about this if we change variables a bit? So I think legal education is going to be, once we get over fighting it, I think that we can become really innovative in our legal formulation and just legal infrastructure for our societies. So I'm optimistic.
Thank you. Amy?
Yeah, so I'm building on what Jan was saying, and I really do see this. I think it's really important, as I mentioned earlier, within legal education, we as teachers, as scholars, we have to really think deeply about how we can help our students to become problem solvers, right? And to really, truly be problem solvers, because that is what a lawyer is at the end of the day. Obviously, we've seen how, AI can answer a lot of questions, right? It can pass the bar exam and all this kind of, but it can't do the same sort of problem solving that requires really deep consideration of the trade-offs, as Jan was saying, to be able to really problem solve on the floor and helping our students to learn these skills and learn how to use AI responsibly. We know it's not going away, right? So it's not all good, it's not all bad, it's how you use it. So we as teachers have to understand it. We need to look under the hood. We can't ignore it. And I do think the future of legal education requires that we actually work harder as teachers, and you can't just show up and have a PowerPoint. I think it's really about being more creative to really help our students learn how to responsibly use these tools to be even more creative and more effective and better lawyers. I always tell my students as well, dispute resolution is not going away. I mean, it's a great area to go into for any student listening to this podcast, because those jobs are never going away. No matter what, there will be problems and there will be clients who need you to help solve those problems.
Absolutely. That's a prediction we can bank on, right? Also,
Yeah.
Jan's prediction that legal education is going to get more interesting. Both of those, I think you're totally solid on. All right. Well, thank you so much, Professor Amy Schmitz and Jan Martinez, for joining us today and discussing the book. If you've enjoyed this conversation, I hope you'll listen to additional thought leaders on Aspen Leading Edge's podcast. Thank you so much.